Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. Today we're going to give you guys an update on Carrington's situation. It's taken a turn, as you know, if you've been following his case. He has two cases, one in state court, one in federal court. Let's look at his state court case and see what's going on. If you're new to this channel, his case number is 11234-2009. And if you want to look at this online, it's free to log into the NYSEF system, as it's called, NYSCEF. You can log in, search as a guest, put in his case number, and you'll be able to look at all of his documents that are on the record, in case you're wondering. So let's take a look. The last things I should say. Interesting information here. As you can see, he had a trial that was dated December 2nd, 2024. And let's take a look at the decision after the trial, which is also on a notice of entry on document 193. Let's take a look at that. Alright, and this was submitted by the other side, Henshaw and Culbertson. Please take notice that within is a true and correct copy of the decision of the Honorable Lawrence Nipel, dated December 2nd, 2024, and duly entered in the office of King's County Clerk. Okay, basically this starts the time clock for him to be able to appeal. Once this has been filed, he has 30 days to file a notice of appeal. So let's take a look and see how the judge ruled on this. As you can see, he put in here trial. He likes writing one-page orders for some reason, not giving you really enough details. And it's saying here, upon the credible evidence adduced at trial, plaintiff has established standing, defendant's obligation under the note admitted into evidence, and default in payment thereon. Both the authenticity of the note and chain of custody, the rest have been sufficiently established. In light of the above finding, this court need not reach plaintiff's contention that defendant lacks standing. Accordingly, judgment is granted in the plaintiff's favor. Submit reference to compute. Note, as prior action was discontinued, as per court order, finding lack of standing, FAPA is not applicable. Alright, and then he signs his name there. So, basically what this says in layman's terms is, when the bank showed up for trial, they had a promissory, they claim it's the original note, but I don't think it was, seriously. And they also produced another note. So they actually produced two different notes at trial, and no assignment of mortgage, and an allonge that wasn't permanently affixed to any note. So he has plenty of reason to appeal this decision, obviously. And let's take a look at a couple of things. Okay guys, as you can see, this right here says Consolidated Adjustable Rate Note. And this is what they presented at trial, or not. Yeah, this is what they say is the original note, and he took a picture of it. Let's take a look at the signature page. Come on, page 3. Here it is. Okay, so take a good look at that signature. Alright, that's what they say is the original note that they produced at trial. Now let's take a look at something else. These were some other documents that they presented at trial as well. A certified copy from Acris, it's like their county recorder. So they went and got documents from the county recorder's office, which these were actually recorded back in 2007. And here's the consolidation agreement. And then let's look at the note on the third page. Let's take a look at that. Alright, here it is. Okay, now look at this signature on this note and tell me if it looks the same as a signature on this note. But they're both claimed to be originals. Well, they claim that they're both the same, but they're not. As you can see, they are totally different. Again, that's the one that they brought to trial, and they say, oh, this is the original note, and this is the one that they presented as documents that was recorded in the county recorder. And again, they are totally two different notes. Also noteworthy is the fact that they did not bring, or they did not present, an assignment of mortgage at trial at all. So, I mean, they had no assignment of mortgage. They had two different promissory notes. None had a longe attached to them. Blank notes, as you know, they can't be used. And so, I mean, they still lack standing, even so. I mean, all these things matter. So he's definitely going to file an appeal. Let's take a look at what that looks like. Okay, so the first thing that he had to come up with is the notice of appeal, which is right here. It's pretty basic. Please take notice that Defendant William Carrington hereby appeals to the Appellate Division, 2nd Department, from a trial of final judgment of foreclosure and sale of the Supreme Court of the State of New York, blah, 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 on December 2nd, 2024. And it's basically stating he's appealing. And then let's look at the next paper he has to do as well. It's an affirmation of service, that somebody that's not a party to the action is serving the other side the notice of appeal, and it has to be notarized. And then the next thing he'll need is it's a form that the state of New York uses, and this is what it looks like. And you can get all this online if you're in a situation that you have to appeal and you're in New York. You would have to follow, I guess, the same guidelines. So basically, the first page of this form, which you can fill out in PDF, you just put the caption, Wells Fargo Bank N.A. as trustee for the certificate holders of Soundview Home Loan 2007 OPT1 Trust against William Carrington. Check the box, civil action, filing type appeal, mortgage foreclosure, and then the next page asks questions such as, it's in the Supreme Court, the name of the judge, Lawrence Pell, Kings County, enter 12-2-24, the case number, and then it says trial. He put yes in the box because it was a trial. And then description, if an appeal briefly described the stuff is, it says briefly describe it, and they put it in this box, right? And this is what he's going to argue in his appeal. Whether the court below erred in granting the trial judgment in favor of the plaintiff. Whether the court below erred in confirming the referee's report. Whether the court below erred in denying the defendant appellant's motion sequence 10. And pretty much same thing, 10, 14, 15, 16, 17, 18, 19, and 23. So he's appealing all these decisions that were made. And then basically it goes into the names of the parties. And then the actual appellate brief he would file within like 3 to 6 months. I think it's 3 months. So, I mean, he filed his notice of appeal with all this. And then when he files his actual appeal brief, it can be done a little bit later, like within 90 days. So, I hope this has been informative and helpful for you guys. And let's all pray for Carrington that he can win his appeal. Because they shouldn't be able to just steal your house like that. And if anybody has any questions or comments, you can leave them in the comment section below. And as always, everyone have a blessed day.